you want me to open or?
It doesn't matter. So let me kind of go over, and we're recording too. I think Mary had mentioned that in an email. Generally, this is a tort claim, right? And the Tort Claim Act is generally a means to avoid a lawsuit.
Correct.
Right. It's a way for the county to look for the evidence and to determine whether they should settle a claim or maybe not settle a claim or do something with it. To do that, the county needs to know all of the evidence and needs to know what the facts are so it can consider that. The entity will look at what the claimant claims and investigate that and then see what evidence the claimant has provided and what evidence that the government entity has and see what the merits of the claim. Potential liability is a factor in evaluating a tort claim, but it's not the only factor and possibly not even the most important factor. Really, one of the most important factors is damages, and that is how much is this claim worth? And that can determine whether the county is willing to settle or less willing to settle, just as much or more than liability. Knowing what the damages are, will allow the county to determine, is this a fair amount, not a fair amount, is there no damages at all, and so they can go from there. And then you might have violated the law, but if the claimant doesn't have any damages, then there's nothing really to settle or pay out.
Are you under the assumption that damages are limited to medical damages, that the constitutional violations are irrelevant?
No, I'm not saying that they're irrelevant.
I mean, that in itself, I mean, there's other damages outside of the medical damages, which is why you get the fact that you keep trying, as Mary said, this is to lay out damages. There are damages that exceed the medical damages. So trying to limit this meeting strictly to medical damages seems disingenuous.
Well, it's not limited to medical damages, it's limited to damage. So, an entity is unlikely to settle a tort claim without any proof of damages. And here, the county investigated it. We looked at the body cam evidence, we looked at the reports, we looked at what you had submitted with your tort claim, right? And evaluated that. But the one thing that was missing was what your damages were. Like, you claimed that you suffered medical injury.
Before we continue any further, I would like to read my prepared statement.
Okay.
So before we begin, I would like to be clear about the purpose of this meeting. I'm not here to argue every unrelated issue or relitigate every prior contact with the sheriff's office. I am here because the August 7th, 2023 incident involving Deputy Rogers raises serious questions about lawful authority, use of force, report accuracy, supervisory review, and the county's failure to train, correct, and document problems after receiving notice on reoccurring issues. To be clear, my claim is not limited to medical damages. The medical consequences are part of the claim, but they are not the threshold issue. The threshold issue is whether Deputy Rogers had the lawful authority to restrict my movement, place hands on me, or threaten that I could have been grabbed, placed in handcuffs because I did not obey an unsupported command. I understand the county may attempt to frame this as a safety issue because Daryl was reportedly armed, but Daryl being armed does not explain why force was directed at me. I was not the person reported to be armed, Daryl was. Daryl was the person later discussing circumstances under which he believed he could shoot me. Yet Deputy Rogers did not physically restrict Daryl's movements, he physically restricted mine. The body camera footage and the report also raise accuracy concerns. Deputy Rogers' report does not simply contain one minor mistake, it repeatedly frames the facts in a way that makes me appear to be the aggressor or obstructionist while minimizing that I was assisting with an emergency tire blowout, that I was on or near my property, that Daryl was the armed party, and that I was objecting to being told where I could and not go on my own land. This is why body camera footage matters. My goal today is to determine whether the county actually reviewed the video against Deputy Rogers' report and statements, and whether any use of force or personal complaint process was opened, whether any Brady or truthfulness review was considered, and whether any training or corrective action resulted. I want to make it clear that that litigation was not my first choice. I attempted to raise these concerns before filing suit. I asked Lieutenant Willard for a meeting to review the body camera footage and give the sheriff's office an opportunity to take corrective action. That request was declined. I attended a community meeting where I was threatened with removal if I did not stop speaking about it during my time at the podium, despite there being no time or topic issues or restrictions. That threat was made by Deputy Baldwin, who is on record admitting he destroyed a previous use of force complaint that I made about Deputy Wiggins in 2019 instead of filing it. I later requested review regarding potential Brady concerns after the body camera footage and Rogers' statements became part of court proceedings related to ownership and access to the disputed driveway. I have also pursued public records to determine whether any review actually occurred. So today I'm asking direct questions. If the county believes Deputy Rogers acted lawfully, I need to understand the specific legal authority the county relies on. If the county believes no policy violation occurred, I need to know who reviewed the footage, what policies were applied, and what finding is documented. And before we discuss settlement value or medical damage, I want to address the foundation of the lawful authority, force, report accuracy, supervisory review, and corrective action.
Okay, I mean, I understand what you said, but again, I think you're misunderstanding the tort claim process. And
I think you're misunderstanding my position. I don't have to turn this over to you before I file the lawsuit.
Right, I understand that.
So I'm trying to give
agree.
you a chance to deal with the entire claim. Well, you're trying to minimize it. I'm not going to allow you to minimize the claim to just one small part. I know you think that that's the smallest part of the claim, and that's why you want to focus there. And you want to avoid the fact that Deputy Rogers committed a 4th degree assault under Washington state law.
No,
And unwanted touching, which is in the Internal Affairs report, it is acknowledged as unwanted touching specifically by his supervisors. That is a 4th degree assault in Washington state, is it not?
Again, you're misunderstanding the tort claim process.
No, I think you're misunderstanding the fact that you need to simply acknowledge the liability and negotiate from there.
No,
If that's not how you want to do it, then I guess we'll have to deal with this in court, and at that point, it's going to include all of the extra litigation costs, not just the damages and what I am due. What I am offering you is a grace offer because I didn't want to do this. I view suing the county as suing myself because I am a taxpayer. My taxes are going to go up the moment this lawsuit gets paid out. I've said that at community meetings. I've said that many, many, many times. I have been dismissed and belittled the whole way through. So if you want to acknowledge liability and negotiate from there, we can.
Again,
thank you for your time. It doesn't seem like you want to.
Not part of this process. What we're trying to do is obtain.
This is what I have
to decide.
Been dealing with in regards to the lawsuit.
Are you going to allow
this
me
is
to
the
finish
this is part of my damages.
Okay, you're not.
This is part of my damages right here. You want to talk about damages? The time and effort put into defending my property. After Deputy Rogers advised them to hire a really expensive attorney to destroy things over there, referring to me and my property. This is part of the damages. This has been going on for 3 years. They are trying to stick me with all of their costs.
Okay.
They have not been able to even produce a legally coherent claim. They can't provide a meets and bounds description for anything they're claiming. They can't provide documented evidence that the driveway has been in the same place for more than 10 years. In fact, Google Street View, you can go on there yourself and see that it is drastically shifted even just since this incident occurred. And yet they're trying to claim in court that the driveway has existed as it currently does for over 50 years. So I am dealing with this because your officer advised the Trask to do this to me. And he is on body camera admitting that he spoke to the Trask multiple times before arriving on scene. And that he thinks she's a cool lady. And he, like, he demonstrates his bias all the way through. I have my list of all the issues within the body camera footage, time frames, or the timestamps, going through both Deputy Rogers' body camera, which is about 2 pages long, onto the third, then Sergeant Dill's body camera footage, and then we have the issues within Deputy Rogers' report, all the factual issues. This one I'm actually going to let you guys have, because you should already have all of that and should know all that already if you've actually reviewed the body camera footage. And if you haven't, then you haven't done a proper investigation.
Okay, well, if I could have finished what we said, that, again, the idea behind the tort claims is to allow the parties to allow the government entity to look at somebody's claim and determine the merits and determine.
And I've given you a number in which I believe is fair, and if you don't agree that that number is fair, then we can settle it in court, and I guarantee you it's going to cost a lot more than that number just to fight it.
I understand, and part of
that was a grace offer. That was like, I feel like you because I made such a low offer, you don't believe that I can substantiate my damages on a much higher level, on a 6-figure level, which I absolutely can. Because not only did I have an emergency surgery, but that emergency surgery ultimately failed, and I had to have a second surgery that was ruled urgent, which was a fusion surgery. A much more significant surgery, one that I am currently in physical therapy for still.
Okay, well, I mean, not having the medical records, I don't know that, but I'm not necessarily saying, disputing any of that. What I'm saying is,
you guys had
you
had a lot of time to try to seek this before.
If I can finish, what I'm saying is, we've looked at the body cam evidence, we've looked at the reports, we've gotten the stuff from your tort claim. What was missing is and you made a $30,000 claim in the tort claim.
60.
Your damage, I believe it was 30, wasn't it?
I think it was 30.
Yeah.
No. See, if you guys can't even, the tort claim, the exact tort claim reserved an amount for much higher. The demand for settlement was for 60. The tort claim itself,
$750.
no, I think it was actually $850. It might have been $750, but I believe it was $850. I'm gonna have to pull that one up on the laptop. But the demand for settlement was 60. And again, that was a grace offer. And you were trying to say, oh, we don't think it's worth even that. That's highly insulting. When my property rights were violated, my civil rights were violated, my freedom of movement was violated, I was the subject of a 4th-degree assault.
And I understand that.
And I'm the reason I'm phrasing it as 4th-degree assault rather than 3rd or 2nd is because 4th-degree assault is true whether or not there was an injury.
Again, I understand all of your contentions.
So again, if the county wants to admit liability, just simple liability, and then negotiate a number, I'm willing to do that.
Again, you're misunderstanding the tort claim
process. I'm not. I'm absolutely not. The tort claim process expired after the.
If you would let me finish.
The tort claim process expired. It's not going to because it's going to be. Go ahead.
But I can't get to that when you keep on interrupting. So, in any event, okay, you made a claim of a certain amount of damages, right? But you didn't provide any evidence of what those damages are.
Am I required by law to do so?
You're not required by law.
Okay, thank you. Therefore, I do understand the process.
But if you let me finish answering your question, but providing an amount and providing evidence to support that will allow the county to more properly evaluate the claim and determine whether it should pay out.
If it's going to be based upon those damages, it's going to be
$60,000
significantly
whatever it
higher
is.
than 60,000.
Again, can you please not interrupt me? And
As long as you want to end on one point and allow me to respond instead of thinking that you can sandbox me with 10 points and not give me a chance to respond and think that because you got away with something 3 or 4 points ago that it's accepted.
That's not what I'm doing. That's not.
You can say that's not what you're doing, but I understand the legal game and I know that that's how it's played. Therefore, if you want to stick to one point at a time, we can.
Well, I have let you speak your piece, and now it's my turn.
If you have a complete prepared statement, I will allow you to read an entire statement and then I will respond. But if you're going to be talking off the cuff, I will interrupt and respond to each point.
I don't see how that makes a difference whether it's prepared or.
Because if
not
it's prepared, then the entire point is the whole statement. But if you're talking off the cuff, your next thought is not something that was necessarily prepared.
Okay, that is true in of itself, but I'm not really sure.
You can
In
disagree.
any event-
If
in
you
any
don't
event-
like the terms of this, we can just end it right now. I'm fine with that. I can file. I know that since you guys did not deal with this or take this opportunity during the response period, I can file. The lack of, you guys just did not do your job from the beginning. The problem is your lack of due diligence. It's not my fault that you're out of time. It's your fault.
No, we did due diligence, we did investigate.
You
The
wanted-
problem here is that you're making a claim for damages against the county as county steward, as the county is a steward of the public and a steward of the public funds. The county needs
And
to
the
have
county violated
evidence
me.
and reason for perhaps paying out a settlement claim.
And I am
And right
offering
here-
a
right
grace
here-
period or
And
grace
right
amount.
right here, we don't have any evidence of the amount that you're claiming.
Do you
you're
have
claiming-
evidence that my civil rights were violated?
Again, that's not part, whether we have evidence of that or not.
That
and
that
whether-
absolutely is, because that
excuse me,
contributes to my damages claim.
Excuse me, and whether or
All right,
not
thank you. Have a good day.
the claim violates the law or not, that's a disputed fact that isn't part of this process. This process is to.
Sorry, sir, but
discuss-
I don't believe that you're taking this seriously, and I am going to be ending this and just following through with the court, because there are rules that the court will protect me with that you clearly have no intention of doing, because as you stated, your intention is to protect the county. Even though I'm a member of the county, you have no intention of protecting me from what has happened, or even doing something to make it right.
I did not
I
say
offered
any of
you
those.
a grace amount, and you want to try to say that what I went through doesn't even qualify for that. With the medical damages on top of that, I qualify for more than that. I
did not say anything of the sort. What I'm saying is, you made a claim for money.
Yes, and then I made you
without
a
any
settlement
proof
offer.
Without any proof.
Have a good day, sir. Jamie, let's go.